I put them on the assignment, but
Let's go talk to them and do some stuff with that.
I'll do my best to figure that out as quickly as possible. Some of that might be able to pull from the OBIT and stuff, but
Shoot orders.
I might have to chase down Dan or.
That's somebody else now. He's not aware of that.
Got it?
Time at 9.
They're all sitting down there with their feet kicked up, just literally. In the hallway after writing their story, and the floors 7 open, like right by the elevators there. But he was yelling at the top of their lungs, pissed about something. They got like the exact words that I was just like, I'm not. judge, a prosecutor, and a family. I'll be on that jury. Thank you. Go ahead and be seated, everyone. All right. We are going to call our next case. This is State of Ohio versus Gerald Dowling Jr. This is case number 24 CR 4353. We're set for sentencing today. Mr. Dowling had previously entered a plea of guilty to count 1 for involuntary manslaughter, a felony of the first degree. The court ordered a pre-sentence investigation. I have received that and had a chance to review that. Can counsel enter your appearances?
Thank you, Your Honor. Dan Leonard on behalf of the State of Ohio.
Jeff Zizek on behalf of the State of Ohio.
Your Honor, Brian Bowen on behalf of Mr. Dowling.
Thank you. Before we begin, there are a number of people in the gallery. I'm going to ask that you all silence your cell phones, turn them off. There's to be no recording or photos taken if you've not received permission from the court beforehand. Please make sure your phones are away and that there are no disruptions. If there are any disruptions in today's hearing, you will be removed from the courtroom. With that, Mr. Leonard, Mr. Zizek, on behalf of the state, what would you care to offer regarding sentencing?
Thank you, Your Honor. States had the opportunity to review the pre-sentence investigation. We do have one clarification we'd like to put on the record. In the section under offender's version, specifically regarding the PSI interview, and I'm referencing the last paragraph on page 5 of the pre-sentence investigation. It states, during the PSI interview, the offender stated the car was running and they jumped into it. He stated the victim came out of the house and yelled and screamed at them to get out of her car. I want to make it absolutely, positively clear. Mr. Dowling was never in that vehicle. There's video evidence. The one individual of the 3 that are involved here is the juvenile co-defendant. His case is currently in juvenile court. We will deal with him at a later date. I want to make sure the PSI is absolutely clear. He was not in this vehicle. It makes a legal difference. So I just wanted to clarify that. With regards to the appropriate sentence in this case, Mr. Dowling's pled guilty, been convicted now of involuntary manslaughter as a felony of the first degree. The court's aware that that case on its own carries a presumption for prison. In other words, all things being equal, the appropriate sentence should be a prison sentence. The state's going to go through our take on the seriousness and recidivism factors quickly. There are a couple things I want to point out. First off, more serious. The victim suffered serious physical harm. Ms. Starkey lost her life. That's about as serious as it can get, mistakenly. But also, victim's child was in the car at the time of the offense. He was in the back seat.
How old was the child at the time?
6
Okay. 6 years old?
years old.
Okay, thank you.
Your Honor, Ms. Stakely had just finished working a shift at a restaurant. She came to this apartment complex to pick up her child from the sitter. She put the child in the back seat and then realized that she had forgotten her cell phone cable. And she took 45 seconds to go back in and get the cable, leaving her car running with her child in the back seat. And in that 45 seconds or so is when this incident set into motion. Since this incident occurred, we've become aware that the child suffered serious psychological harm as a result of this. We originally thought the child was asleep and didn't know. Turns out that was incorrect, and it started to reveal itself in the months following this incident. So in a very real sense, we have 2 victims here who have suffered unbelievable harm, death and serious psychological harm. For less serious, we will submit and we will concede that none of these people expected to cause serious physical harm out of this. That's not why we're there. They were there. Mr. Dowling, he was there to take items out of cars. When the opportunity presented itself, the juvenile co-defendant decided that he was going to take the car. They didn't expect to cause serious physical harm. We'll concede that, but it certainly occurred. As far as the statutory factors for recidivism being more likely, we'll also concede that there are simply none that apply. He has no juvenile record. He has no adult record. He doesn't show a pattern of failed community control or probation or anything else. Those factors simply don't apply. As far as the factors the court must consider for determining whether or not recidivism is less likely, the state will concede that all of those apply with the exception of whether or not its circumstance is not likely to recur. Frankly, these circumstances, this was such a lineup of random events, there's no way to judge whether or not this could occur again. The question then becomes, what weight should those be given? And the state submits that those factors, the fact that he has no prior record, the fact that he shows genuine remorse, the state believes they're not entitled to a great deal of weight. And I want to talk about remorse as well. Mr. Dowling expresses remorse. We honestly and truly believe he is remorseful. We're not alleging that Mr. Dowling or any of the other kids are monsters. But what happened here, this event was monstrous. And that's entitled to some weight. Mr. Dowling was there in those apartments going through cars, looking for things to take. And the court's well aware that you can't go more than a day or two, these days it seems, without hearing on the news about people breaking into cars or people stealing cars. We just had, 40 broken into up at Polaris this last week. You can't go a day without seeing a news report about people going into cars and stealing stuff, or stealing cars and taking them. Part of the purposes of sentencing are for the incapacitation and possible rehabilitation of the offender, but also deterrence. This event, the death of Miss Stakely, is the worst case scenario of what could happen when you're out stealing cars or stealing from cars. This was a momentary decision that had unbelievably profound impact.
Can I interrupt you, Mr. Zizek? Because I don't know that the court should consider, the idea of sending a message as one of the sentencing factors that I have to consider. I mean, it sounds like you're kind of creeping into that kind of argument. Is that, I understand deterrence, there may be a deterrent effect, but,
Well, and Your Honor,
it,
the only thing I can point to is 292911, where it indicates that at least one of the purposes is to deter the offender and others from committing similar offenses.
okay.
The message here
I'm
is,
sorry, go ahead, continue.
and the message here is not punish Mr. Dowling harder. This is the worst case scenario. This is as serious as it can get when you look at what the intention was and what the results were. At this time, I understand that there's family members that would like to speak. This is probably the appropriate time.
We can take their statements at this time. Who would you like to call first?
Right here, okay.
Yeah, that's fine. Can you state your name for the record?
Yes, Alex Franken. I'm a victim witness assistant with the prosecutor's office.
Are you reading a statement, Ms.
I
Frank?
am. I am reading a statement on behalf of Alexa's parents, Andy and Sandy Stakely, who could not be here today.
Go ahead.
Of course, he pleaded guilty because he is guilty. This plea does not mean that he doesn't deserve retribution. He actually doesn't deserve a free life out of prison at all. He knew there were consequences when he chose to break the law, especially when he showed no concern regarding her life, nor did he attempt to rescue her once she fell from the hood of the car. It took weeks before somebody else turned him in. Where's the remorse? He has also had no remorse since being incarcerated that we are aware of. We have not received a letter, and we are not hard to find. Pleading guilty does not mean that he regrets what he did and or would not do it again. Pleading guilty just means that he agrees there is no benefit of doubt that he did his part as the adult amongst juveniles, the influential one in the group, in 1, wanting to steal Alexa's car, 2, in participating in the act of stealing her car when he most likely saw that her son had just been loaded into the car, 3, in not intervening when innocent Alexa tried to stop the theft of her car and our grandson because he was in it, and 4, in not running out and yelling and screaming to stop his buddy by committing to drive away in her car, causing her to fall from the hood and possibly get hit in the head by the tire as his buddy squealed away. His upbringing, his circumstances, and his ideologies, nothing justifies him breaking the law by wanting to steal a car and, in turn, participating in taking another person's life. Her son's mother's life. Alexa was not born with a silver spoon. She had a difficult childhood, yet did not allow herself to be a victim of her circumstances. She became a great asset to her community and our world, being a help and blessing to others. What has he done with his life? He took someone else's. Thank you, Your Honor.
Thank you, Ms. Franken.
Now we have Alexa's brother that would like to speak as well.
Good morning, sir. Could you state your name for the record?
I'm Braden Price. I'm Alexa's brother. I want to start off by saying I didn't come here today to tell you what you probably heard 100 times already. I hope you have the humanity in you to understand what you guys did was very wrong. And you robbed a lot of people of great joy, and that little boy, he's never going to see his mom again. But I came here today to tell you that I forgive you. And I know, and I hope you have the humanity in you to understand that this shouldn't ever happen to anybody's family ever again. But I want to tell you that apart from my forgiveness, the bigger thing from this, and this goes for everybody in this courtroom, that God loves you and that he wants a relationship with you and that he can turn you away from this nastiness and this bad path that you're on right now. And regardless of whether you get a long sentence or a short one or probation today, I pray that you please receive him and try to be a message for others so they don't put other people's families through this. And for you and your family, I pray the best for you guys. I hope you can all learn from this and grow as people closer to God and be a good representative of the community and what humanity is about. Thank you.
Is it Mr. Bryce?
Braden Price.
Price. Thank you. Thank you for being here, Mr. Price. I appreciate it. Yeah. Mr. Zizek, Mr. Leonard, any other statements?
Your Honor, in conclusion, this case carries a presumption for a prison sentence, and the state believes that a prison sentence is appropriate under the facts and circumstances here. We'll stipulate the 380 days of jail credit. That's for the period of July 24th, 2024 up through today. Your Honor, the state's position is that the presumption for prison in this case has not and cannot be overcome based on the facts and circumstances of this case, that a prison sentence is appropriate, and we would ask the court to impose an appropriate sentence at the Ohio Department of Rehabilitation and Corrections. Thank you.
Thank you. Mr. Bowen, have you had a chance to review the pre-sentence report?
I have, Your Honor.
Are there any corrections or any omissions that you wish to note?
Your Honor, not beyond what was already stated by Mr. Zizek.
Okay. What would you care to offer on behalf of Mr. Dowling?
Your Honor, I'd actually like to start. There's a gentleman here, Reverend Ben Price, who actually knew Mr. Dowling significantly when he was younger, who would like to say a few words on his behalf.
We can have Reverend Price come up. Sir, if you'd like to approach the cart here in front of the bench.
First of all, I'd like to correct something. I'm not a reverend, okay?
Okay. I'm sorry.
I've worked through the church. I've known
Okay.
Gerald since he was an infant, a toddler. Unfortunately, his father was incarcerated, so we were able to fill that gap for him. We helped raise him. I made sure he was at school every day and that he went for after-school programs to keep him out of the streets. And we worked very hard to teach him a lot of things. And one of the things that we taught him was accountability and responsibility, sir. And he realized that he must be held accountable for his actions and accept responsibility for it, okay? You can't take things from people, okay? Because you don't know what the outcome is going to end up. And unfortunately, we see this now. But he's really a good kid. He's never been in any trouble in his life. How he got with these kids, only God knows. But I know that I was with him when he was doing right, and I'm going to be with him when he's wrong to show him how to be right again, okay? He has to rectify this situation and clean this up. Only he can do this. You know, and I have a lot of faith in him. I'm going to be working with him while he's incarcerated and after he gets out of jail again. I just hope that this court understands that this guy is not a criminal. He's not a monster. He got caught into a bad situation and a bad act, made a very poor decision. And he must account for that now. I'm asking that the family, I understand your loss, and your young boy, I'm traumatized thinking about him and what he's going through in his mind. But, you know, we can all grow through this together. And through the grace of God, something good can come out of this. I just ask that this court will see this, sir.
I want to thank you for being here today, Mr. Price. Thank you. Mr. Bowen, what would you care to offer on behalf of Mr. Dowling?
Thank you, Your Honor. Your Honor, this has been an extremely difficult case to work through. We appreciate the prosecutor's office and their understanding of sort of the relative culpabilities of the people involved. They made the decision to charge Mr. Dowling with the involuntary manslaughter. We believe that was an appropriate charge, and we appreciate their discretion in filing that charge rather than potentially a murder charge against Mr. Dowling, given the specific facts of the case. Your Honor, in working with Mr. Dowling over the last 300 and some days, I have found him to be, he's pleasant, he's emotionally appropriate, he's remorseful, he understands the nature of what happened here and what it cost not only Ms. Stakely, but also the other members of her family, including her child and her parents. These are people who were deeply harmed by this. There is no way that he can ever necessarily set that right. I know that he has some words that he would like to say to you specifically about that. Your Honor, in looking at this case and looking at the recidivism and seriousness factors under 2929-12, it's always difficult to argue the seriousness of an offense where someone has lost their life. It is by nature, by definition, an incredibly serious offense where someone has died. And it feels ghoulish to argue that one taking of a life is somehow less bad or less serious than another taking of a life. That said, it is important to acknowledge a couple of things here. Number one, there does not appear to have been any action on Mr. Dowling's part to affirmatively go after that vehicle. Mr. Dowling never got into that vehicle. I think those are important facts to acknowledge here. Obviously, that's why this is an involuntary manslaughter and not a murder. But when looking at the other seriousness factors under Section B, we don't believe that any of those really apply. Obviously, he didn't have a public officer trust, no professional reputation that helped to facilitate the offense, no relationship with the victim, not for hire as part of any organized criminal activity. And we appreciate the state's acknowledgement that when looking at Mr. Dowling's previous criminal history, which is non-existent, that that's not a significant factor, that doesn't make this worse, and in fact, that speaks well to him. He had led a law-abiding life. He had not previously been adjudicated delinquent or convicted of any previous offenses. And that makes this case particularly difficult. Here's someone who engaged in bad activity in terms of going out and potentially looking to steal stuff from cars or open doors of houses. And when you're in for a penny, unfortunately, you're sort of in for a pound. But the question here is, really...
Let me push back on that a little bit, because if let's say he's not in the car, she gets run over tragically. If he calls the cops right away, he's not sitting here, right? Maybe he's not looking,
Right.
I mean, it took Mr. Hawkins turning himself in. If I'm understanding the facts correctly, he turned himself in and implicated Mr. Dowling. Mm-hmm. And that was about 10 days to 2 weeks where we didn't know, no one knew what happened, no one, right?
Right, no, that's true.
And so he could have mitigated this. He could have stopped the weight, right? He
could have mitigated it sort of after the fact.
Yeah.
Right.
But that would go towards a mitigating factor.
It would.
Okay.
I agree.
And he didn't do that here.
I agree with that as well. However, he did then voluntarily speak to the police. He did voluntarily, engage in behavior that took responsibility for what his actions were. And I think he was pretty forthcoming as far as the pre-sentence investigation goes.
I agree with that. I agree.
When you look at the pre-sentence investigation for people that we see who are engaged in, who are involved in a situation where someone died, this is about as good a PSI for the defendant as we see in those situations. He's got no record. He was forthcoming. He scored fairly low on the various assessments, at least from the information that's in my copy. We don't get the full report. This is a young man who got into a situation that got way out of control. As the state said, it ended up in the worst case scenario for this kind of situation. Ms. Stakely lost her life. Nothing that we say or do can atone for that. The only thing that Mr. Dowling can do is ask the court to give him a sentence that allows him to eventually go back to what he was doing before. He was working. He was leading a productive life. This isn't someone who has made a history of bad choices. This is somebody who's made a history of decent choices. We ask the court to impose a sentence that allows him to do that, allows him to go back once he has served his time, once he has done whatever the court imposes on him, to go back to leading the sort of positive, contributing life that he had led up to this point. And like I said, I know that he has some things that he would like to say to you.
Thank you, Mr. Bowen. Mr. Dowling, you do have the right to make a statement at this time. What would you like to say to the court?
You want me to read it for you? If you can get through it, I would say do it yourself. Can you do that?
I can try.
Okay. All right.
I want to start off by saying sorry to the victim's family, my judge, and my family. Day and night, I think of what could have happened different. It is very sad and unfortunate that someone lost their life. Those were never my intentions. This situation haunted me every day since it happened. And today I get a chance to repent for my sins and take my time with respect and as a man. Sometimes things that you can't control happen, and for that there are consequences, and I 100% respect and accept that. I would like to say thank you to my judge for a second chance back into the community. I learned from my mistakes. I know things could have played out different. I feel a weight being lifted off of my shoulders today, and I will take this time with an open mind to new possibilities to become a better man. I also want to say thank you to my family for supporting me through this rough patch on my journey through this situation to manhood. And thank you to my attorney for being great and guiding me in the right direction.
Thank you, Mr. Dowling. I do appreciate your statement. Before we proceed to sentencing, I did want to ask the prosecutors, Ms. Stakely, she was a teacher, correct?
Yes, Your Honor.
And was it through a private school or Canal?
The Canal Winchester school system.
Okay. I just wanted to make a comment, and it's tangential to the case, but, the fact that Ms. Stakely worked as a public educator and a teacher and had to work a side job is absolutely disgraceful. And it is, I come from a family of educators. My mom was a teacher. My dad was a teacher. My sister's a teacher. My uncle's a teacher. Everyone in my family is a teacher. And the fact that the people who pull the levers of power refuse to adequately pay and support our public educators is disgraceful and shameful. You know, and I'm not blaming her in any way at all. Like, I don't want it to be taken out of context. Like, she shouldn't have to have a second job when she's a teacher. She shouldn't have to be taking her child to a babysitter so she can go work in the food service industry. And I grew up in the food service industry. I've worked several jobs. It's an honorable profession, but it is hard. It is difficult. And to work that, you spend all day teaching kids and then go to work at a restaurant or a bar. She should have never been in that position where she had to do that. And it is absolutely disgraceful that we treat our educators and our teachers, the people who take care of our children, with such disdain and scorn and you just chiseling away at their ability to make a living doing an incredibly important job. It is just absolutely shameful. And Miss Stakely should have never been in the position where she had to work a second job to make ends meet when she's got, I assume, several degrees and licensure, and she should have never had to work as a waitress or a bartender or, it's just absolutely, it's shambolic. It's just, it absolutely should have never happened that she would have to be out at, past midnight picking up her child from a babysitter so that she could work a side job to make ends meet. And that has been underpinning this entire situation. And, I would be remiss if I didn't point that out, that she should have never been in this position to begin with. And that is not to blame her at all in any way. Our society shouldn't punish teachers for going into the profession of educating young people. And, hopefully, I feel like that comment was appropriate given the facts of this case. Turning to the actual sentencing factors and the facts of this case, I would note for that counsel did meet with me in chambers and showed the court one of the security videos of the incident. By agreement of the parties, and Mr. Bowen, Mr. Leonard, Mr. Zizek were all present, I had an opportunity to view it. This is a video that would have come out at trial had we had a trial in this case, and it is heart-wrenching, it's disturbing, it's tough to watch. The court has a number of factors that it has to weigh in determining what the appropriate sentence should be. The fact is that, and I agree with Mr. Bowen, that it is ghoulish to compare, is one death less worse than another death? But the fact is that Ms. Stakely didn't deserve what happened to her. She's trying to do her job. She's trying to do multiple jobs, one of those jobs being a parent. Having to have a babysitter and go out and work a second shift, she just wanted to get home and probably get some sleep before the next day. And she forgot, a power cord or something that she needed. She runs back into the babysitter's house to grab that thing and comes back out, and some jerk is stealing her car with her child inside. And it is totally foreseeable that she would jump on the hood to try to protect her son. And I understand that Mr. Dowling wasn't the person behind the wheel. He wasn't in the car, but he was out patrolling, taking stock, scoping out what cars can we break into, what packages can we steal off of people's porches, what can we get away with. And I think the letter from the family, it touched on something that I had thought as I was preparing for the sentencing today, is that you were the adult. You were the grown man. I understand you're 20 now, you were 19 when it happened. You were the adult. You could have walked away. You could have said, no, man, no, don't do that. Don't do that. when it happened, you could have, and I brought this up earlier, you could have called 911. You could have called anyone in the media. You could have called the police. You could have said, hey, I was there. This happened. And I saw it. It was Mr. Hawkins, the juvenile, who his case is still pending. I don't know if he had a guilty conscience, but the facts are in the PSI, and I read them. He turned himself in. He's the one who said you were there. And, you know, there were things even after the event happened, after she was hit, after she was run over, you could have stepped up and done your part. You could have at least helped. You couldn't make it right. You couldn't bring her back, but you could have done something else. And you didn't do anything until Mr. Hawkins gave your name to the police. And that's how they found you. And you're the adult. They're juveniles. They should know better, but it's kind of like, I don't know, like being the oldest child. It's on you to do the right thing, and you didn't do it. And there is absolutely a punishment that needs to be paid. And I do agree with Mr. Zizek's discussion about deterrence, that one of the purposes of sentencing is to deter future conduct. And I think especially in this case, in a situation where we live in a city and a county where there are a lot of car thefts, this is the absolute worst outcome, and it was totally unnecessary. And you had the ability to, if not prevent it, stop it, mitigate it, make it less worse than it was. Their family waited 2 weeks to figure out what the heck happened and who did this. And that is, you could have ended that waiting, suffering a lot sooner. I do agree that your statements are remorseful, but had he never turned himself in, I don't know that you'd be standing here right now, because they wouldn't know. It would be an unsolved case. Because I don't believe that you would have turned yourself in on your own. I don't believe you would have had the guilty conscience to say, this thing happened and I saw it and I need to report it. I don't think you would have ever done that, and you're the adult. This is an extremely difficult case, and the court has thought a lot about what the appropriate sentence should be, and I've considered all of these sentencing factors. And I'm accounting for Mr. Dowling's lack of a prior history. I'm accounting for his, not being the primary individual involved in what happened to Miss Stakely and her being run over. The court believes that the appropriate sentence is that Mr. Dowling serve a term of prison of 7 years at the Ohio Department of Rehabilitation and Corrections. The court will consider judicial release when Mr. Dowling becomes eligible, and I will indicate that in the sentencing entry. I will award 380 days of jail time credit. Mr. Dowling, I'm going to advise you and remind you that if you serve the full 7-year sentence, that upon your release, there's a mandatory period of post-release control of at least 2 and up to 5 years. If you violate post-release control, you could serve an additional 3.5 years. I'm giving you the opportunity to file for an early release when you're eligible. I'm factoring that into the court's sentencing decision, that when you become eligible, I will consider you as long as you have demonstrated that you are taking your rehabilitation seriously and that you are committed to fixing the decision-making process that led you here, because you were not thinking that night. You were not being a leader. You were not being an adult. And Mr. Hawkins and the other offender, if you were the adult there, maybe this didn't happen. But, Mr. Hawkins will have his own case that'll play out on its own. But in terms of your involvement, the court believes that a 7-year sentence is appropriate. There is a presumption in favor of prison. The court finds that, based on my review of the pre-sentence report, that presumption has not been overcome. I'm not going to impose any fines or costs. There will be no financial sanctions. Technically, it is a sentence of 7 to 10 and a half years in prison at the Ohio Department of Rehabilitation and Corrections. Your sentence is presumed to end after 7 years. However, under the Reagan-Tokes Act, your sentence may be extended by up to 50% or 3.5 additional years if the adult parole authority finds that release is not appropriate at the time that you've completed the 7-year sentence. Is there anything else on behalf of the state?
No, Your Honor.
No, Your Honor. Thank you.
Thank you. Mr. Bowen?
Your Honor, due to Mr. Dowling's indigence, I would ask the court to suspend any fines or costs.
I already did that, but yes,
Thank you.
I will make sure that there are no financial sanctions.
Thank you.
Okay. Thank you, everyone. That'll be all.
Thank you, Your Honor.
All right. The court is going to end the video feed at this time, and the court's going to take a 5-minute recess.